Well, hello there, and welcome back to this edition of the Employment Law Show. Good to have you along for this 30-minute ride. There is a lot of information we will give out to you, free, of course, and very useful if you have a job anywhere in this province, in this country. That is why we do that. Workplace rights, employment laws, that's what we focus on. So stay tuned for the next 30 minutes. You will have a chance to reach out when I give you the contact information, and you'll learn a ton as well. We always have a main topic. It is your right to accommodation, what your employer must do. That is coming up in the second segment of the show. To reach out to Lior anytime, you know how to do that. 1-855-821-5900. Help at employmentlawyer.ca, and the only website you need for all your concerns, including access to that severance calculator, which we like to showcase every week. That is pocketemploymentlawyer.ca. John Scholes here, Lior right there. We'll get to all that over the next 30 minutes. But week that was is how we kick it off every week, pal. What do you got going on this week?
Well, we'll kick it off again today the same way. So we are here to talk about employment law and to resolve workplace issues to help you understand what to do if you're facing a workplace problem. It is extremely rare that in the course of your working life, things are always going to go perfect, that you're not going to have an issue, that your boss is always going to treat you well. It's not likely going to happen. That's why this show is so important. That's why we need to understand rights, because those issues will come up. Maybe when you've lost your job, unexpected, but the law is there for you. Maybe all of a sudden you have a new boss and the new boss is not treating you properly. They're making claims and allegations against you. How to deal with that? That's a form of harassment, right? We'll talk about those things. Maybe you're sick and can't work and you're dealing with a workplace issue and accommodation. We can talk about that. The law is very, very strong. I think you get it. In Ontario and frankly across Canada, we have some of the best employment law rights anywhere. People don't always know what those rights are. On the show, you will. You will learn your rights, you'll learn what to do, and you'll make sure, we'll make sure you know how to get some help. That help, of course, is to reach out after the show. We can have a private discussion. We'll give you that contact information throughout the show, so please use it. That's why it's there. Now that we know that, let's talk about the case of the day. I spoke with a gentleman who had been off on a medical leave for right around 10 months, almost a year. He was off on a medical leave, serious medical condition, worked really hard to get better. His employer didn't bug him, let him be off on a leave, so everything was fine. Well, after about 10 months, he was cleared to go back to work, no limitations. He was very happy, again, worked really hard. Contacted his employer and said to his employer, I'm ready to come back to work. When can I do that? His employer said, yeah, great to have you back. Just so you know, we've gone through some major restructuring, though, over the last 10 months. So your old position doesn't exist anymore. We have a different position for you that we're happy to give you. It's a very different role. It's actually with lower pay. But, you know, we love you. We want you to come back into this new position. The employee was concerned about it. He didn't want to do that role, had worked in that previous role for quite a few years. And he contacted me, and he wanted to understand his rights. Now, the thing is this. Clearly, his employer is not picking on him because of his disability leave. It was a major restructuring, nothing to do with him, and his position legitimately doesn't exist anymore. But does that now mean that he has to take that lower level position? The answer is no, absolutely not. Just like an employer cannot change your position or demote you in a regular situation, they can't do that when you're coming back from a medical leave. That's a constructive dismissal. So his employer is saying, well, we have a job for you, so you have to come back. Not necessarily, not even close to being true. If that position is a lower level position or a lower paying position, if it can be seen as a demotion, he does not have to accept that. That could easily be a constructive dismissal. He can get his full severance. This guy's worked there for about 10 years. He'd be easily looking at a year's pay. So, message and a reminder here that whether you're coming back from a leave or you're working and your employer wants to change your job, your hours, your pay, that may not be legal. That may not be something your employer is allowed to do. Think constructive dismissal. And of course, before you do anything, before you commit to going back or not to go back, we need to talk.
Does an employer have any wiggle room as to bringing you back as far as position, maybe not pay, but do they have any leeway at all?
So the basic rule, John, is an employer cannot make significant changes to terms of employment. So yes, could your employer make some changes? Sure, absolutely. If it's a minor change, if it's not a demotion, you know, you're going to go from the east side of the factory to the west side of the factory, you know what I mean? Those types of changes, absolutely. But if it's a significant change, whether it's because it's a demotion and it's not as prestigious, or your pay is being affected, or your hours are being reduced or changed, that's a constructive dismissal. That's the threshold. Once it becomes significant, of course, it's not always obvious what is significant. That's where we need to talk. Not every change is illegal. Not every change is a constructive dismissal. But if you're facing a change, we need to at least have that discussion so that you understand your rights.
If, the rare occasion that it went the other way, meaning you're coming back from a medical leave and your employer says, well, your job is no longer here, as you mentioned, but hey, Christmas came early, we're actually giving you a better job, a little more pay. Even if you don't want that, you're not comfortable with it, can you still say no, even though it's an upgrade?
Yes, again, the same significant change. If it's a different role, but it's really not that much of a difference. Maybe it's a bit more responsibilities, but 97% is the same. Your employer can probably do that. But if it's a significant change, even if it's a change for the better on paper, it's still a significant change. It's not what you signed up for. I signed up for this job. I don't want to take another job with a lot more responsibilities. It's going to stress me out. It's going to create more work for me. I don't need this. That's still not something your employer is allowed to do, even with a promotion. So if your employer insists on doing that unilaterally, that could absolutely be constructive dismissal.
As you know, Lior gets a lot of phone calls at the firm after the show, and before our viewer phone calls like to chime in and ask their questions. We get to 2 or 3 of them every week. We'll get to our first one right now. Listen up.
A friend of mine, she's in her early 30s. She's been a waitress at the same place for about 8 years. The property was sold to a land developer, and they're closing the whole place down. The owners went to all the waitresses with contract agreements, which she didn't sign, and in it said that they were only entitled to 2 weeks severance. And I told her she has to get a hold of you.
It almost sounds like this is left over from COVID, because so much of that happened during the pandemic, restaurants shutting down, being redeveloped, and these type of stories, right?
Very common, and certainly during COVID, but we see this often, redevelopment, restructuring, what have you. And she's right. Her friend does need to call me right away. Why? Because it's not the fact that she's going to lose her job. Your employer can ultimately let you go, and in this case, it doesn't seem like they're picking on her. It's a question of severance. So this person, after 8 years, was said, well, we're going to give you 2 weeks severance. It's almost like the employer feels like they're doing her a favor by giving her some severance. Nonsense. Severance is not a favor. Severance is a legal requirement if you lost your job. Doesn't matter if you work for 6 months, 6 years, or any other period of time. And it's easy to think that because she's a younger person and not a senior position, she's a waitress, that she may not have entitlements that are significant. Nonsense. She does. So I'm going to show you how to assess entitlements in this case and in every case. We have our severance calculator tool. You'll find that, of course, at pocketemploymentlawyer.ca. I'm going to use that right now and show you how much she's actually owed. So we know that she's been a server, a waitress for about 8 years. She's 31 years of age. Her employer is offering her a favor, they think, I guess, 2 weeks pay, except it's not a favor, it's nonsense, because what she is owed is 8 to 10 months potentially of severance. 8 to 10 months. So that's why we use the severance calculator. Again, pocketemploymentlawyer.ca should always be the very, very first place you go to if you lost your job or even if you're concerned about losing your job.
This one's interesting, too, because you and I both know a lot of people, friends, et cetera, that are in the service and hospitality industry. First of all, 8 years in one place, she's a veteran.
Yeah.
In that industry, she's a veteran. Second of all, because they move around so much, I think a lot of employers just say, oh, you're here today, gone tomorrow. 2 weeks is good enough. Out you go, because you'll get a job whenever, tomorrow. Right?
Nonsense. And certainly these days it may be more difficult to find jobs. There's more people looking and less jobs available. So no, severance is there to help you, to carry you until you find new employment. That's why you don't want to accept 2 weeks, because what happens if it takes you 6 months to find another job? How are you going to live? That's why that severance is there for you. That's your insurance policy. That's your security blanket to carry you till that day when you find another job.
Phone call number 1 was great. Let's move on to phone call number 2.
My colleague, he's about to be demoted and questioning, if there's any options available to him, not taking a demotion. Is it possible that he or she could walk away?
What type of job does the person have?
It's a sales job.
And what's the demotion going to be to?
Rep, essentially.
How long have they been at this company?
5 years plus.
And would there be a reduction in pay?
That's right.
So an employer often knows that a demotion is not really legal. So what they may try to do is say, oh, it's not really a demotion, just a change in job. So we're not changing the title, or we're giving you a title that's equally as senior. But that's nonsense. If I demote my CEO to my assistant, but I keep the title of CEO, that does not matter. What matters is the reality on the ground. So if you've been demoted because you've been given a job that's not as senior, a job that's less responsibilities, a job that's not going to look good on you, when your colleagues are going to say, what happened with this guy? He used to be in the senior role and he doesn't have it anymore. That's a demotion regardless of title, frankly, regardless of change in compensation, which means constructive dismissal. Your employer is not allowed to do that. Your employer is not allowed to demote you into a position that's very different than what you had. And if they do, you could potentially treat that as a termination and get your full severance, again, up to 24 months pay. Now, that becomes the argument for constructive dismissal becomes that much stronger if they're also reducing your pay. So now it's really a constructive dismissal. But even without a reduction in pay, even without a change in title, if you're practically being demoted, that may absolutely be constructive dismissal.
So even based on prestige, not pay?
Yeah.
Wow.
Yeah, again, what matters is the reality on the ground. If it looks like a demotion and it feels like a demotion, it's a demotion, which means it could be constructive dismissal.
Third phone call is coming up on the other side of the break, and our main topic as well. Much more employment law show coming straight up, so stay with us.
People think you have to sign back a severance offer by a deadline. EmploymentLawyer.ca says that is a myth. Deadlines are used as a pressure tactic. Make sure the offer is fair before you sign. Always check with the employment lawyer first at EmploymentLawyer.ca. Can insurance companies deny long-term disability claims for mental illness?
When you're suffering from a mental health disability, insurance companies just don't understand. But we do.
They can absolutely not force you back to work. If your doctors say you are not ready and you know you're not ready, they cannot make you go back to work.
If you have a mental health disability and your claim is denied, don't give up. Give us a call and let us fight for you.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think you aren't owed severance pay if you are fired for a reason. EmploymentLawyer.ca says that is a myth. Most for-cause terminations are false, and you are still owed full severance. Always check with the employment lawyer first at EmploymentLawyer.ca.
And welcome back to the Employment Law Show. Again, John Scholes, Lior Samfiru, employment lawyer. Reach out, employmentlawyer.ca, help at employmentlawyer.ca through email. And that phone call, 1-855-821-5900. Speaking of phone calls, we always have 3 per show from our viewers before we get to our main topic momentarily. So let's get into that third and final show phone call for the week. Here we go.
I've been with the company for quite a while, almost 25 years. I'm able to get a copy of my employment contract. I looked in my records, I couldn't find it. I asked the company. They're saying they're unable to locate it. I'm anticipating something happening soon, so I just want to get all my ducks in a row. What happens in that situation? If I were to be let go, with regards to my benefits?
Is there a calculator?
Yep.
So, very important. First of all, if you don't have an employment agreement, that is a good thing for most people, okay? If you have an employment agreement that you signed at some point, that is bad news. That employment agreement would take away rights that would be yours automatically, like the right to get full severance, like the right not to be put on a temporary layoff, and many other things. So a lot of people get very upset if they realize I've been working here, I don't actually have an employment agreement, I never signed anything. They send me an email at some point saying start on Monday, and that's all I have. That is good. You don't want that employment agreement. You don't want anything like that at all. So be very, very happy that you don't have that. So, of course, in this situation, after 25 years, if he loses his job, he's going to have significant entitlements, as much as 2 years' pay. That's what we need to assess when that time comes. But the message here, very simple, very clear. Don't worry. Don't freak out. Don't be upset if you don't have that written employment agreement. That all thing that means is you have the full protection of the law. That's the best case scenario.
Especially a 25-year employee. He'll be okay.
Yeah. So I'll give you an example.
Right.
An employment agreement could have limited this 25-year employee on termination to as little as 8 weeks severance. 8 weeks. Without an employment agreement, he could easily be owed 2 years' pay. So you do the math. The difference between 8 weeks to 2 years, massive, huge. That employment agreement that you may so want could be the worst thing for you.
We're going to roll right into our main topic for the show, by the way, your rights to accommodation. What employers must do. Number one, your employer must adjust your duties or schedule, right?
Yeah. So When it comes to accommodation, as long as you have that doctor's note that stipulates that you need an accommodation to your schedule, that you need changes to your hours of work, your employer must provide that, and they can't avoid it. They can't say no, okay? Your doctor rules the day when it comes to that accommodation. And a very common type of accommodation is that change to your schedule, your duties. Maybe you need light duties. You can't lift more than 20 pounds. Maybe you need to work reduced hours. Those are legitimate, very common types of accommodation, and your employer must do that. They can't say no. And listen, I understand and appreciate that sometimes for the employer it may not be easy to provide that accommodation. It may cause some logistical problems, even financial issues. But the law is still very clear that that accommodation has to be provided. As long as it's not outrageous or over the top, your employer must provide that accommodation. If they say no, that could easily be a human rights violation. It's illegal. Start with that doctor's note. And if your employer won't give you that change to your schedule, to your hours, to your job that you need, we need to talk about it right away.
The second point that employers must take care of, and a lot of them they get really tempted to do this and they misstep, is your employer must refrain. Do not demand your diagnosis.
So you've provided your employer with your doctor's note that says you need accommodation, you need light duties. Your employer may say, well, I want to know if it's legitimate. I want to know if that employee really needs that accommodation. Maybe they don't. So I want to know exactly what the medical condition is, because if they're dealing with a bad shoulder, why are they asking for to sit down? You know what I mean? Stuff like that. Guess what? It doesn't matter. Your employer does not get to demand your diagnosis. They don't get to demand your medical file. You have privacy rights. So the privacy rights include not telling your employer what your medical condition is. Your employer can demand to know what accommodation you need, for how long. They can even ask questions, when will you be reassessed, so we can get some more information. Legitimate questions. Not what your diagnosis is, not what the treatment you're getting, and not your medical file. So it should be irrelevant to your employer whether you're suffering from a bad knee, bad shoulder, or maybe it's a mental health issue. What matters is what accommodation you need as dictated by your doctor. So no, you should not provide that information. There's good reasons not to mention you have a right to privacy.
Talking about your right to accommodation, what your employer must do. Point number 3, your employer must not fire you because of your mental condition or that request for accommodation as well.
So a lot of people are concerned, and I understand the concern is, well, if I'm kind of that squeaky wheel, maybe I'm asking for accommodation, I'm asking for help, is my employer just going to let me go, or I need to take time off for medical leave? Are they going to say it's just going to be easier to let the person go? Well, no. The answer is absolutely not. They cannot do that. You cannot be let go because you're sick or you have a medical condition or because you need accommodation. Even if it's easier for your employer, it's completely and totally illegal. That would be a human rights violation. It would also potentially be a violation of employment standards, not legal. You should always know and remember you're protected if you're asking for accommodation. You have to be provided for that accommodation, and your employer cannot let you go because of it.
Final point, Lior, this week on this topic about accommodation, what your employer must do is your employer must provide you with proper severance pay if you lose your job.
So in most of these cases, your employer is not even allowed to let you go. But maybe there's a major restructuring or major cost cutting. Maybe it's a situation where you've both decided that this relationship is not going to work, so we're talking severance at that point. Yes, you're still going to be owed your full severance. Now, the one thing I will say is, I just said you're owed your full severance. You actually may be owed more than your full severance. If you're let go at a time when you're not physically 100%, where you have some medical restrictions or you're dealing with the health issues, the law says you should get even more severance than you would have gotten if you were healthy. The reason for that is because it's potentially going to be harder to find a job if you're not well, if you have restrictions. It's going to take you longer to do it then than if you were 100%. So that's reflected in your severance. So not only do you have to get severance if you lose your job when there's a medical condition at play, you get even more severance. That could be a lot more, which is why no matter what, I don't care what the situation is, who your employer is, or what the condition is, you cannot and should not ever accept that severance offer without having a discussion with me first.
We have that covered off for this week. The main topic, we are going to take a short break, come back with another free website you can use anytime to ask questions called terminationquestions.com. That is next on the Employment Law Show. Stand by. We're coming right back.
People think you should go to the government to get severance pay. EmploymentLawyer.ca says that is a myth. Government can only help you get minimum severance, but not everything you're entitled to. Always check with the employment lawyer first at EmploymentLawyer.ca. If your long-term disability claim is denied, should you appeal?
Appeals often fail because insurance companies control the process. So long as you appeal, you're playing by their rules.
You should never appeal the denial of your disability benefits. Appeals are just a mirage of false hope.
Don't. That's their process. Take it out of their hands and fight for your rights with our help.
Go to disabilityrights.ca. Discover your rights, fight back, and get what you're owed. People think their employer can make changes to their job. EmploymentLawyer.ca says that is a myth. Your employer can't change your pay, hours, or duties. You may be entitled to full severance pay. Always check with the employment lawyer first at EmploymentLawyer.ca.
All right, welcome back to the Employment Law Show. Glad you stuck around through that short break. We're going to keep on rolling. I did mention a free website you can use to ask your questions anytime. They may appear in a future show called terminationquestions.com. Free and anonymous, of course. From Lior, here we go. For this week, says, after working as a technician for nearly 6 months, I made a mistake, and my boss put me back on probation for another 3 months. During this period, another error occurred, and I was let go. And I was considered on probation. I'm not offered any severance. Is this legal? I'm in my early 50s and worried about how hard it will be to find a new role. So probation, no severance, second probation, and out you go.
So there's a couple of things that are completely wrong about this. Number one is you can't really be on probation for more than 3 months, because if the employer wants to let you go without any compensation, that period of time cannot be greater than 3 months. And of course, it's only if you sign an employment agreement that says that. But there's another issue, okay? You can't be put on probation, okay? You have to agree to be on probation. If an employer, forget about the 3 months, if your employer wants to put you on probation, it's not a unilateral thing. What does this mean practically? It means that this person is owed severance. Your employer cannot avoid paying you severance by saying, I'm putting you on probation. Okay, it doesn't work that way. Then I can always have an employee that maybe worked with me for 30 years, just say that they're on probation, then let them go, and I don't have to pay you anything. Man, how smart am I? Of course, it doesn't work that way. Okay, if you're beyond the 3 months, unless you've done something terrible, something that's so bad that's not possible to employ you, yes, you're going to be owed severance. And I want to remind you that even short service employees have significant termination entitlements. This person only worked for 6 months. So it's easy to think, okay, yeah, fine, severance, but how much is severance going to be? Is it going to be a week's pay? It's not much. Nonsense. Short service employees have significant entitlements. How significant? Well, let me show you. I'm going to use the severance calculator once more for this 6-month employee that's not on probation. So I'm going to go to pocketemploymentlawyer.ca right now and assess his entitlements. A technician, been there for a few months, only 51 years of age. An employer says, we're not going to pay you any severance because you're on probation. Nonsense. Doesn't work that way. You can see there he's owed as much as 4 months severance. 4 months after only a few months of employment. That is significant. So whether you work for a few months, by the way, John, funny story. I saw a Facebook ad recently, a video that another law firm that doesn't practice employment law posted online saying, if you worked for more than a year, you may be entitled to severance. Like, what are you talking about? That's ridiculous. That's suggesting that if you work for less than a year, you're not entitled to severance. Yeah. Ridiculous. Not true at all. It doesn't matter to me if you work for a month, 2 months, a year, 20 years, you have significant termination entitlements. And if you lost your job, we need to talk.
You know, the genesis of this was this person made a mistake. That's what got them let go. So say it's a case where someone's being induced by another company to come along. They pull you from current employment and they say, oh, by the way, part of this, we're going to put you on probation for 3 months. Don't allow that, right?
Yeah. If you're going to leave a secure job to join an employer, why ever agree to be on probation? Because you're leaving a secure job with all the security that comes with having that job for a long time. They're coming to you to induce you to go to another position, and you're going to do that and be on probation? Don't ever agree to that. And if they insist, it's probably not the right place for you anyway. You're better off staying at your secure job. But certainly, best advice I'm going to give you, if you're going to leave a secure job to join another company and they want you to sign an employment agreement, man, oh man, please don't do that without speaking to me first.
You can join Lior and the other lawyers in the firm. They do a great job in the live stream. YouTube, Facebook, LinkedIn. Join in at ST Lawyers. At ST Lawyers to do so. From it for this week goes like this, Lior. I've been working 50+ hours a week in a salaried role and was told as I'm misclassified as management and not owed any overtime pay. I don't supervise anyone or make high-level decisions. How can I ensure my rights are protected and not being taken advantage of?
So the reason why this is important, and I've seen this many times, is that managers, true managers, are exempt from overtime rules and overtime laws. So if you're an actual manager, you don't get overtime, and that's a problem. Well, the law understands that a way one could try to get away with it is by calling someone a manager when they're not. Well, it doesn't work that way. If you have the title of a manager, but you don't manage people, you don't have people under you that report to you, you're not a manager. I don't care if you're called the most senior manager, you're the executive director. If you're not truly a manager in terms of your job, it means you're not a manager, and that means you are owed overtime, okay? Title doesn't matter. The same thing, by the way, applies in reverse. You could have a non-managerial title, but if you do the job of a manager, then you are a manager, which means you are exempt from overtime. So not good enough for the employer to give you the title to avoid paying you overtime. If you're not, you're owed. And a reminder there that overtime is paid for most people if you work more than 44 hours a week in Ontario. Other provinces have different rules. Time and a half has to be paid. So do the right thing, do the smart thing. Don't just fall for that title. If you think something is wrong and you're not getting paid what you're owed, yeah, let's have that discussion.
So quickly, though, I mean, people may be watching, okay, they're salary, though, not hourly. How do we calculate overtime for me?
So let's use Ontario as an example. So whatever you earn in a week, you divide that by 44. That gives you an hourly rate, okay? And that hourly rate is good for 44 hours. Anything over 44 is time and a half, 1.5 times that hourly rate. Very simple to calculate that. So yes, salaried employees also get overtime. And again, just because you have the title of a manager, but you're not really, it doesn't mean you don't get it. You still do.
We always wrap up the show with Lior in the hot seat called Employment Rights Rapid Fire. Let's do that right now. Okay, right at it. Employment Rights Rapid Fire question number 1, Lior. Can your pay be deducted as a form of discipline?
No. Absolutely not. John is grimacing here, as he should. Your pay cannot be deducted generally for any reason unless you give written consent to do that. Certainly not as a form of discipline. Completely illegal.
Rapid fire number 2. Can you be laid off for taking maternity or parental leave? These are great questions this week.
No. You cannot be let go because you took a parental leave, whether you're a father or a mother. Your job is protected. It's what we call a job protected leave. You have to be brought back, same job, same pay, same hours. You cannot be let go because of it. Illegal.
Don't mess with mama or papa, right?
Ever.
You got it. Rapid fire question number 3. Do you have to accept a severance offer on the spot immediately right now when it's handed to you?
Your employer may want you to do that, either on the spot or by the deadline. Not only do you not have to, you must not do that, because that severance package is extremely likely to be inadequate and your employer wants you to accept it so that they save a bunch of money. Nothing happens on that deadline. Your legal rights don't expire for 2 years. That's why you never accept that severance by the deadline. Get some advice. Let's do this the right way.
Next question. Is your employer obligated to pay you a bonus?
So if you have a deal with your employer, whether it's based on past practice or based on an employment agreement that requires them to pay you a bonus if certain milestones are met, they have to pay it. They can't take it away. On the other hand, if there's no deal, bonus is discretionary. Sometimes they pay, sometimes they don't. It's up to your employer. Many people have strict and very clear bonus terms, and an employer must abide by them.
Thank you, Clark Griswold. Last one. Can your employer let you go for filing a harassment complaint?
Man, no, ever. You have the right to tell your employer they're being harassed or mistreated or bullied, and you have what I call the dome of protection around you. Your job is protected. Nothing bad can happen to you. You can't be penalized, certainly not let go. Even if it turns out that you can't substantiate or prove that harassment, nothing bad can ever happen to you. So always feel free to advocate for yourself, to tell your employer in writing if you're being harassed or mistreated. Anything that they do to you that's wrong, let me deal with it.
And we got them all in, so we got to go. Email help@employmentlawyer.ca and call 1-855-821-5900, and we'll see you next time.